An indictment is a formal accusation that a person has committed a crime. It is a crucial step in the criminal justice process, primarily used in serious criminal cases. Below, we delve into what an indictment means, how it is issued, and what happens after an indictment. What is an indictment? An indictment is a formal written statement issued by a grand jury charging an individual with a criminal offense. It signifies that there is sufficient evidence to believe that the accused person committed the crime and should be tried in court. The indictment process. Here is a step-by-step overview of how an indictment is typically issued. 1. Investigation. Law enforcement agencies investigate the alleged criminal activity. This involves gathering evidence, interviewing witnesses, and compiling reports. 2. Presentation to the prosecutor. Based on the investigation, the law enforcement agency presents its findings to the prosecutor. If the prosecutor believes there is sufficient evidence, they will present the case to a grand jury. 3. Grand jury proceedings. Selection of grand jury. A grand jury is assembled, which usually consists of 16 to 23 citizens. Presentation of evidence. The prosecutor presents evidence and witnesses to the grand jury. The grand jury proceedings are generally secretive, and the defense does not participate. Deliberation. The grand jury deliberates in private to decide whether there is probable cause to believe that the individual committed the crime. 4. Issuance of indictment. True bill. If the grand jury finds sufficient evidence, they issue a true bill of indictment, formally charging the individual. No bill. If the grand jury does not find enough evidence, they return a no bill, meaning no charges are brought. Post-indictment process. 1. Arrest and initial hearing. Once an indictment is issued, an arrest warrant or summons is typically issued for the accused. The individual is taken into custody, if not already, and an initial court hearing is scheduled. 2. Arraignment. During the arraignment, the accused is formally advised of the charges in the indictment and asked to enter a plea: guilty, not guilty, or no contest. Bail arrangements or release conditions may also be discussed. 3. Pretrial proceedings. Discovery. Both the prosecution and defense exchange evidence and information. Motions. Pretrial motions may be filed by either party to address evidentiary issues or other legal matters. 4. Trial. If the case is not resolved through a plea agreement or dismissed in pretrial motions, it proceeds to trial. During the trial, both the prosecution and defense present their evidence and arguments before a judge or jury. 5. Verdict and sentencing. If the accused is found guilty, sentencing occurs, where the judge determines the appropriate punishment. If found not guilty, the accused is acquitted and released. Key points to remember. Role of the grand jury. The grand jury does not determine guilt or innocence. Instead, it decides whether there is probable cause to proceed with a criminal trial. Secrecy. Grand jury proceedings are held in secrecy to protect the reputation of the accused, who has not been formally charged yet, and to prevent tampering with witnesses and evidence. Right to defense. The accused does not have the right to present their case or have their attorney present during grand jury proceedings. An indictment is a formal step that moves a criminal case from the investigative phase to the trial phase, indicating that there is probable cause to charge the accused. Understanding the indictment process can help individuals better navigate the complexities of the criminal justice system.